was a reasonable and necessary expense. Doctor looked at it and says, hey, listen, they didn't need a hard cap in this instance. It wasn't called for. All they needed was a prescription, but they did this hard cap. Well, so then the question is, do you let the case, do you let them enhance the value of the medical because a expense was not reasonable and not necessary?
Well, I think it would open up the door for. I think it opened up the door for other things. Essentially, let's assume I'm a reasonable person and I got all the operations or, hospital care that I needed to get taken care of, but I'm not allowed to mention that I got hospital bills. I can't even mention that I went to the hospital and here I have, maybe 50 to 100,000, maybe ballpark it, or maybe just, it seemed like, if you
talk about your bills and what you paid and everything.
Yeah. So if they wouldn't let you talk about it, though, that would sound like it would seem like, okay, you got injured, but you didn't have to have any hospital bills. So if you weren't allowed, if you weren't allowed to mention it, if you weren't allowed to even mention that you had hospital bills, that would substantially impact the decision because the person, maybe you got injured, but they don't know what the extent of the injury was because they don't even know, the dollar amount.
Oh, you get to talk about your bills, yeah.
Okay.
But the challenge on the backside is what's reasonable and necessary. And, you've got to be careful when you're talking about your bills.
Yeah.
Because if some of them come up that aren't reasonable and necessary, then you're going to have a real challenge in court, and it really detracts from your case. So in most instances, though you can talk about your bills, you would probably at least, most attorneys would have someone that reviews those that will testify reasonable and necessary expense.
Sure.
And then when the witness gets on the stand, they'll talk about all those things that their expert told them was reasonable and necessary.
So you're saying, just to clarify, a judge says you cannot talk about your medical bills, you can't even mention that you had them, or you can't mention any dollar amount, that would be appealable?
Well, now, when you talk about appealable, it's like appealable versus what's a reversible error.
Right.
People will file appeals over a lot of things that's not a reversible error. And what you're speaking of is so factually dependent that you about have to go through it piece by piece to see what the bill was, see what the expense was, see what the testimony was, see what the doctor said, and then you got to apply the discretion over the top of it as to whether the judge let it come in or didn't let it come in.
Right, okay.
So that's a pretty factually dependent question that likely would not lend itself to a general answer. A lot of things in the law, a lot of people look for, well, what's this do? And it's like, well, this is a pretty complicated question. If it wasn't, then we wouldn't need lawyers and judges because we could go to the library and it would have this example and it'd say ABC, and if ABC happens, you get D. Well, you don't get that. That's because you have the law, it gets interpreted and applied to different situations. And you have how many of our circuit judges in the state of Kentucky? I can tell you how many appellate judges you'll have. You'll have 14 in the Court of Appeals and 7 Supreme Court justices.
Okay.
Because Kentucky is divided into 7 appellate districts.
Right.
That's the 3rd appellate district. And each appellate district will have 2 Court of Appeals judges and 1 Supreme Court justice. Of course, you have Court of Appeals. It's the tier system in the state of Kentucky: district, circuit, Court of Appeals, and Supreme Court. Supreme Court doesn't hear everything.
Right.
So that question is more factually dependent, and one fact can change, and it can go one way, and almost like a switch.
Yeah, I got you. I got another example here, but I want to, before you did say it's a reversible error if a judge does not allow you to have an attorney if you requested one and you're, clearly you can prove that you're poor.
Well, most of those that I've seen that's probably proving that you're poor has been, they just filled out an application with the pretrial officer and stated their income, I'll be honest, I don't know of any judges that go and conduct a hearing to look into your income and your expenses, etc. If we did that, I'm not sure how we'd get through the month, because I may have 75 indictments returned in a month, and if I had to do 75 hearings trying to determine what their income was, it'd probably be at least 2 hours a hearing, so that'd be 150 hours. It takes about 10 weeks.
You said before, though, as a judge, you err on the side of essentially assigning lawyers to anybody and everybody that wants one, even some people that don't even want one. So you would be okay, but I'm just saying.
Let me say this. I will err on the side of protecting constitutional rights.
Yeah.
So, because if you're going to get reversed, you get close to one of those constitutional rights, and then you have 3 appellate judges that look at it. And you got to remember, when you're at the trial court, let's see how best to relate this. Do you watch basketball games?
Yeah, I played basketball.
Oh, okay. So you're out on the court playing basketball, and one of the refs blows the whistle and said somebody did this. Somebody fouled, or you fouled somebody.
Yeah.
Well, you're in the heat of the game when you do that.
Yeah.
And he's kind of in the heat of the game, trying to watch real quick what's happening.
Right.
And then they play it all in slow motion. Well, that's kind of like your court system, because your trial court, I make decisions in 5 seconds as a trial judge that I can sit and talk about for 5 days at the Court of Appeals.
Right.
So there's a time frame there, and your trial judges, they're not going to be perfect. Why? Well, they didn't sit for 5 days to think about that one decision that came up. It's in the middle of the case. The jury's sitting there. The witnesses are sitting there. You got the Commonwealth over here, a criminal defense attorney over there, as well as the defendant. Or you've got a $50 million civil case sitting there, and you have 3 or 4 high-powered lawyers on one side, maybe just one local attorney on the other. So you've got to kind of draw and make your best shot as quick as you can to keep the case moving.
Okay.
If you stop for 5 days, the jury would say, what were we here for now?
Well, how about your body of work? What are some notable cases that had reversible errors that people from Kentucky could say, oh, okay, that's not right in trial court. That's an error that could be appealed.
Well, that would probably be best to just take Westlaw or Lexus and look at the opinions I rendered, because those will have what we saw as reversible on the basis of the facts of those types of opinions. A lot of times, in my opinion, mine are a little more wordy, because I try to set out the reasoning as to why I did and how I made the decision. And if what I did on the appellate decision just said, well, we're going to overrule or we're going to affirm that trial court.
Right.
And I don't give you a factual analysis, or I give you a short factual analysis. And if I don't give you enough that you understand my reasoning, then when a similar case comes up, you won't have that reasoning to be able to apply to the next case and say, oh, and I'll give you a good example of that. We had one come up on DUIs, and it was talking about whether or not the state police followed their procedures and what procedures were consistent with constitutional requirements. Because now they may not follow their procedure, and their procedure, if they didn't follow a procedure, that may not be reversible. But if that procedure hinged upon a constitutional requirement, or you had constitutional requirements otherwise not met, then you have a problem. It's like a traffic stop. When they set up a traffic roadblock, that is to some extent an infringement on it's a seizure. They have seized you for some short period of time.
Yeah.
Now they're looking for certain things, and they're supposed to put out, flags to show that there's a stop coming up in Kentucky. You've got to advertise that you've got to have roadblocks along. You'll have a roadblock set for Saturday from 6 a.m. to 6 p.m. along Kentucky 192 in Laurel County to get people noticed so they're not shocked when they come upon it.
Right.
And they have in the state police will have certain designated areas. They'll have checkpoint number 31, checkpoint number 32. But those particular ones that relate to the constitutional, you got to be careful of that because, like I said, that's still a seizure. Somebody's stopping you for some period of time.
So, just real quick on Colorado Constitution, Section 4, if I think the right to revolution is enshrined in Kentucky's Constitution.
Rights of revolution.
Yeah.
I'd have to go back and review that particular one.
Okay, yeah, right. Check it. Section 4.
Before I could probably talk about revolt, I don't know. Revolt's never been real popular in Kentucky.
No. I think it comes from the Revolutionary era, so it's saying that if the tyranny of the government became too much, then the safety and the happiness, there's three things, happiness and safety and something else, if those are ever in question, then the right to change the government. I forget how they word it, but I'm pretty sure I understand it as a right to revolution. Colorado's got the same statute in the Bill of Rights too. Yeah.
I don't know if we've really done that here. Certainly not in my lifetime. Possibly, someone could consider these crimes that are committed as some form of a revolt.
See, that's what I'm wondering is like, how would you, I don't think, it's probably never been applied to, it's probably like that arbitrary, there's another freedom in the Kentucky Bill of Rights about free from arbitrary control, something like that, and it's, how would you apply that, the right to revolution? So it seemed like a little petty crime. No, you did not steal Snickers because you're fighting the man.
It's, well, what you get into is if you start looking at many of those constitutional rights have been well litigated. You know, your Fourth Amendment, your Second Amendment, First Amendment. When you get to some of those that aren't, it's like they changed the Kentucky Constitution years recently concerning rights of victims, or they enacted a statute, rights of victims.
Yeah.
Well, one of the most liberal organizations out there pointed out, do you realize that when Joe the burglar comes into your home and you shoot him, he may have rights as a victim at that point? And it's like, now you enacted a statute, we got that. It'll take us 30 years of case law to figure out who really gets these rights, and what they get when they get them, right? And who gets how much of which one.
I like that there's some sort of balance, because there's the rights of the criminally accused, right? That's enshrined in the U.S. Constitution. So it seems like, okay, we got to protect the criminal's rights, but we should probably protect the victim first, right? Shouldn't we protect their rights first?
Well, sure. Well, I mean, first of all, the victim's not doing anything, so he ought to have the right to be safe and secure in his home and his place of living. And certainly, when you look at your criminal rights, you're looking at due process.
Right.
He has a right to be heard.
Right.
You're not just going to look at him and slam it down and say, well, you're guilty here.
There's a bunch of witnesses. You could compel witnesses. You have a right to remain silent. There's a whole slew of rights for criminals.
Oh, yeah. You have a right to remain silent. Any sentence you make any will be used against you. You have a right to a lawyer. You cannot formally apply for one. They seek pre-trial services, drop the application, and submit to the court, and see if you qualify for an attorney. You have a right to call witnesses, cross-examine witnesses, and you have a right to trial the jury, which is actually, trial the jury is once it's the jury verdict, you can appeal the jury verdict. You have those rights.
What's the difference between a 6-person jury and a 12-person jury?
Well, basically it's 6 people.
Okay. Oh.
It's a 6-person jury. Right. Well, you have a 6-person jury in district court in the state of Kentucky. You'll have 12 people in circuit.
Oh, okay. So for
will try more higher dollar amount as well as penalty range. In your district court system, your penalty range on misdemeanor is going to be a year or less.
Okay.
Whereas your circuit court is year to death.
Right, I got you.
And your jurisdiction in your district is, I think currently it's set at 5,000 or less. And your circuit court is 5,000. Sky's the limit.
Okay.
So probably actually based on the heft of the matters considered, we'd like to have more people do it, you know. If we're going to send it away for life, we'd rather have 12 jurors in agreement.
Right.
And, you know, if we're going to start jacking around with the numbers, we just go to 2. So if 2 of them agree, you know, that cuts your chances down, right? Every time you have an additional juror, that's someone that the Commonwealth has to convince beyond a reasonable doubt it's a criminal matter, as well as it's a chance for the defendant to be able to get somebody to vote not guilty when it goes back to deliberation. On
the flip side, though, isn't there some courts of limited jurisdiction where essentially there is no jury trial? So, like maybe I don't know, a cheap case, a jaywalking case, or maybe a shoplifting under $20.
I don't know of any case in district court that we wouldn't try to a jury. I mean,
okay.
You have probate cases, but that's not a jury tribal issue.
So that would be a reversible error. That would be if you were denied a jury trial when you requested one, that would be a reversible error, right?
Well, yeah, that's probably going to be a reversible error. I don't know of anybody that would actually do that.
But if they did, it's hypothetical.
Oh, sure. Yeah, if you were denied a jury trial, because you're guaranteed a jury trial through the Constitution, and you're sitting there saying, I want a jury trial, where's my jury? And the court says, you don't get a jury trial.
Right.
Now, it's, you know, there could be some statute on which the court is relying. I don't know what that would be, because I really don't know of any crime we had in district court in our system where you couldn't get a jury trial. You get one on a speeding ticket if you wanted.
Right.
For registration. You know, any criminal charge we had, you could get a jury trial on.
Okay, good. We found a reversible error. I have 5 more questions.
Well, see, really what your reversible error there you're finding is a constitutional right. It's a solid violation, and by solid I mean, you know, there's no way around it. You obviously violated a constitutional right.
Yeah, and that would apply for all constitutional rights too, right?
That follows for all constitutional rights, so long as it made a difference in the case, and I think most would. Now, let's take, you know, suppose right to witnesses. You have a right to cross-examine a witness the Commonwealth puts forward.
Yeah.
Well, the court cuts you off and say, no, you can't cross-examine this witness. Well, I really don't know of any instance in the law that would allow you to just cut off that cross-examination.
Right.
I was actually, years ago, when I was practicing law in federal court, the federal judge kind of told me to speed it up there. I was cross-examining this text.
Yeah.
I just told the judge, I said, well, Your Honor, I can stop anytime you order me to. And he just looked at me and said, go on with your cross-examination, because he knew if he told me to stop cross-examining,
right,
more likely than not, now they may have looked at it as repetitive cross-examination, or, you know, I wasn't introducing any new material and I totally exhausted it. I'm not saying that's it, but there's arguments to be made on the other side. But basically, that was like me saying, you know, Judge, I can stop if you know it's reversible error. If you stop me and he'd look at it and say, yeah, I know it is. So you just go right on. I'm not going to build this case already.
Then you would have them. You'd have the appealable, something to appeal it on.
Well, yeah, it's but then you'd be retrying the whole case again.
I got four more questions. Sure. For Kentucky citizens, would you take one of their appeals just as seriously as a lawyer's?
What now?
For a Kentucky citizen, would you take one of their appeals briefs? So a citizen writes the brief. Would you take it just as serious as a lawyer who writes a brief?
You mean someone that represents themselves?
Yeah.
Or you mean, okay. Well, sure. Whatever briefs they file. Now, what you've got to do, in those briefs, there is, I think Rule 76 controls that. You've got to have adequate citation to the record.
Okay.
You can't file a brief and say, this is my story. You got to tie it to the record. This is my story because here the judge ordered this. Look at page such and such.
Or put some KRS into it, some of the statutes.
Well, it's not just KRS. It's where the judge did it.
Okay.
Because if you don't, you understand some of those records, when they come up on appeal, they may be 10 or 12 bankers' boxes full of records. Well, if what you do is just submit a brief and say, this is my story, you've got to tie all those things in the brief back to that record.
Okay.
You've got to show where it occurred and what the judge said, and when I said the Court of Appeals, that's why as two staff attorneys, that's what we did. We looked back at that record to see, when you submitted that brief, we looked to see that occurred.
Okay.
And when you told us that judge did this, we looked to see that he made that ruling.
Right.
Be surprised how many people missed that. And I've sent briefs back and said, you didn't do it. So when you appeal that, you are really held to the same standard of law that the rule requires. Whatever standard that rule requires.
As a lawyer, so essentially...
Whether you're a lawyer or not a lawyer.
Right, okay.
And it really doesn't matter if you're not a lawyer, other than the fact that your skills may not be as sharp as you need to be.
Right.
To meet that rule.
So you're just saying as long as the brief says maybe the story, but also connects it to the case and the evidence and the ruling.
They want you. That brief has to cite back to the case to show us where it is, where the alleged error or where whatever took place, whatever you're talking about. And at the Court of Appeals level, procedurally, you only review what the trial court did.
Yeah.
You don't produce any new evidence.
Right.
So it's all tied to that record.
Okay. Now, when it comes to what Kentucky law is, that term Kentucky law, first I guess the easy question is common law. Does Kentucky law respect common law?
Common law is well statutory. Common law is found in the cases. And you've got statutory law. Right? You have some statute. Statute says don't speak. Speed limit's 55.
All right.
And you'll have common law that applies to certain other things. And that's developed in your cases. And a lot of it interprets your statute. And you'll also have some common law left on certain causes of action that come up.
So it sounds like yes, because in Colorado specifically, common law is not respected. It has to be statutory, statute or a case or constitution.
We still have common law causes of action and so.
Okay. So tell me if I include everything that I need to for what Kentucky law is. If I read the U.S. Constitution, the Kentucky Constitution, I read the federal and state statutes, and then Supreme Court benchmark cases and common law. Is there anything else that I would have to read to understand the full body of Kentucky law?
Well, you let me know when you read through all those Southwest Second.
Well, the state statutes,
some volumes now.
Just the statutes would take forever. There's no way anybody's read every law out there, but
all those cases, and those are just the reported cases. You do have this procedure in the state of Kentucky whereby you can cite to unreported opinions. And it's like there's nothing else on point. You need that. That's closely aligned with what you're talking about, etc. But the reason it wasn't reported is because that panel didn't think that was the didn't put it forth in there and didn't want it reported. Any of those that I put down and reported in the books, we always went back through. We took out anything that could be considered dicta that somebody pulled out of it and then get an incorrect rule of law out of it. So we pulled that out. And I mean, there was always a dichotomy that existed between you published and unpublished. Somebody wondered why you publish them. Well, I can tell you the published one's probably 400 some volumes. Who knows how many could be in the unpublished.
Right.
But when you read all those, you be sure and call me back, and I'll talk to you probably in another 15, 18 years.
Well, there's also not only those, but the thing about planning and zoning, and then local ordinances too. So that's in addition to what I've already mentioned.
Sure. Yeah, you can read all those. And the problem with it, and I think this occurs with a lot of younger attorneys too, and I've cautioned them before. I said, you know, a lot of things, you read the statute, and you may not understand it the way that the department or the case law has interpreted it differently. So you read one thing, and you say, well, that doesn't apply. Whereas someone that's more learned on the subject says, oh, yeah, it says that, but, you know, you've got these 22 decisions behind it that explain exactly what that means. So it's real important in the case now. So to say that you read the statute, if you read the statute and read all the cases that interpret that statute, I'll talk to you in a couple of years.
Right.
That single statute, and you can let me know what's there.
So then what do lawyers and judges do? Because you essentially are admitting that you haven't read all the laws that would be, you know, part of Kentucky law. So you have to do shortcuts. You have to just take the lawyer's advice. Because there's no way then the legislature's passing all those new laws too. So not only do you have, you know, the Constitution and the court cases and case, now you got new state statutes.
Well, we rely on Westlaw and Lexis and our intellect and our experience built up over the years at whatever trial level we've been at.
Yeah.
So if there's a particular statute, when I key that statute in, I get all the cases that have referenced that statute. Now, Westlaw uses a different algorithm for returning you cases.
Yeah.
Lexis, as I understand it, if you put in KRS 329.01 and anything that follows, you know, exclamation point or whatever the symbol is they want used at the time, it returns everything that's got KRS 329.217, 218. You get it all.
Yeah, I'm familiar. Do you like? No, I'm sorry.
A lot of it depends upon your attorneys, you know, and how well they argue and what they bring to you.
Yeah.
Obviously, it's to their benefit to cite to everything that's in their favor, as well as cite to some things that aren't, that they can explain away and why it doesn't apply to the particular case.
Right.
And because you can't lay all that on it, if you put it all on the judge or on the appellate panel, what they're really asking them to do is you're just throwing your case up there and saying, hey, listen, I think I'm right on this. Won't y'all do all this research so that you tell me what's going to happen? Well, there's something to be said for having an attorney with a lot of experience.
Yeah.
Right? And he's experienced in the area. And, you know, so that he can present that in a very logic and streaming fashion and explain away why those other cases don't apply.
And a citizen,
probably the best attorneys I've seen could take an oral argument at the Court of Appeals and flip it around, and you ask them questions, and they flip it around like a Rubik's Cube and come up with the answer every time. And those really know what they're doing. They read the cases, and you may have one or two very interpretive cases at a particular point, but they'll be followed by a bunch of cases, any number of cases that will kind of fine tune. So you know, you got to fit within the seminal case